Hello everybody and welcome to the Risk Management and Insurance series of lectures. My name is Thomas Harben. Just by a few comments by way of background, I am the General Manager of the Legal Practitioners Indemnity Insurance Fund, the LPIIF, and I've been with the organization since 2009. Before that, I was in practice, and I practiced for over a decade. I was fortunate to have worked both in a large commercial firm as well as in a small legal practice. So I think I've seen quite a wide variety of what can happen in legal practice. None of us can say that we've seen it all. And I've been conducting these lectures for the PMT course for about the last 7 years. And because this has been done virtually, unfortunately, I do not have the benefit of having conversations with you and finding out, first of all, what type of practice you are running, the structure and the areas of work that you are conducting. And secondly, I also missed the lessons that I've learned from the candidates in the PMT course over the years, because people have given very deep insight into the risks that they have seen in practice. I have a presentation that I'll take you through, and I'll just stop my video. I will be available to answer questions on the eLeader site, so please post your questions there, and I'll answer them on a weekly basis. Okay, this module will be presented. I've broken it down into 5 sessions because there's a lot of information that is given, and for some people this information may be new, and thus don't want to overwhelm you with the information in one sitting. What we'll do today, we'll start with a brief introduction to the subject of risk management. Then in the second session, we'll go into a deeper examination of the main risks facing legal practitioners, and also suggest appropriate risk mitigation measures that you can implement in order to, in respect of each risk. In the third session, we'll look at the different types of cover that are available to legal practitioners, it's insurance cover, that is. And the next session will go into an in-depth discussion on the Legal Practitioners Indemnity Insurance Fund and the Fidelity Fund. And then in the final session, we'll go through the assignment. Please note that I will not answer the assignment for you, but in taking you through the questions, I'm hoping that you'll be able to get an idea of what is required of you. I need to also make the disclosure that I've once again drafted the assignment this year, as I've done for the last 7 years. And then I'll also give you a list of risk management resources that you can use. And I'm hoping that what you learn in this component you'll use in your practice, and that you'll also share it with your colleagues. as well. So I'm not going to start with a textbook definition of risk management, but I'll just explain briefly what the process entails and what the benefits of risk management are. So risk management, broadly speaking, is a process in terms of which you analyze your operating environment, both internally and externally, and identify those risks that will affect your achievement of your strategic goals. You could also look at the likelihood of the risk materializing. Some risks may be remote, and also the potential impact. The severity of risks is not the same. But it's important that you design and implement risk management measures to meet those risks that you have identified, or to assist the firm in overcoming the risk. And no two legal practices will ever have identical risk profiles. There are some risks that affect legal practitioners generally, but there are others that affect certain types of practice more than others. But every firm is faced by the risks, because none of us operate in a vacuum. Factors that will affect the types of risks in the legal practice are matters such as the areas of legal services you provide. You'll note when we show you the claim stats that certain areas of practice are riskier than others, or rather that they carry a higher risk than others. The size of the firm and its structure. You could have on the one extreme a legal practice that's made up of one practitioner who may be practicing from home, for example, and that practitioner needs to do everything. There are risks that are associated with that. On the other hand, you could have come from a practice with hundreds of practitioners, many layers of support staff, lots of things happening in the background that you may not even need to, you may not even be aware of. There are firms that have, if we look at the risk of theft, for example, there are firms that have huge, a large number of staff in their financial functions, carrying out with various checks and balances in place, with huge systems in place in order to mitigate that risk. Also, your geographical location, how long you have been operating, the culture in your firm, your prior conduct, the effects of the legal services market, the viability of your practice, and the regulatory environment all affect the risk profile of your firm. And not all risks can be avoided, and the potential impact of each risk will vary. The point of this course and other risk management courses is to teach us how to deal with those risks. And it's also your attitude towards risk management is important, and that will determine what benefit you take out of this course. Do not view risk management as another level of bureaucracy. It's not just another voice standing on the hilltop and telling you what to do, how you need to go about doing what you want to do in your legal practice. And also, don't just view this as another tick box exercise and go through the motions in carrying out your risk management, your risk management exercise. Everyone in the firm has an important role to play in risk management, whether these be professionals or support staff. If I can use an example that we often give legal practices, is that in many law firms have a resource or resources that are dedicated just to delivery of documents, service of documents and filing. If when you look at the claim stats, and you'll see how many claims arise from a failure to meet a statutory deadline. Prescription claims, for example. If you do not explain that to your messenger, they won't understand the impact of what they do and how important that is to the general sustainability of your firm, because you can have one risk materializing, you can have one claim that could threaten the very existence of your firm, because it may be a large claim in terms of quantum, and you may not have adequate insurance cover to indemnify you for that risk. And if you have the discussions with your staff and you explain the importance of risk management up front, don't wait until something goes wrong when it becomes a blame game. It's easier to train people when things are going well and there are no stresses faced, whether they be in respect of disciplinary action from the regulator or a claim from a client or a third party. And because you are running a business enterprise, it's important that you take cognizance of what good governance, the good governance standards say. One example of these is Principle 11 of King 4, which states that the governing body, and governing body refers to you, the legal practitioner, the partner, the director in the firm, should govern risk in a way that supports the organization in setting and achieving its strategic objectives. Please read the King 4 code. It has important principles as well related to ethics. I noted that as lawyers we have a set of ethics and professional standards with which we must comply, that's set out in the Code of Conduct and in the jurisprudence that has been developed in the courts over the years. But there are a lot of learnings from the King 4 code as well in respect of ethics, risk management, and how we should conduct ourselves in our businesses. And why is risk management important? It ensures the sustainability of your firm, because if you would have multiple risks materializing, or even one significant risk materializing, it could threaten the very sustainability of your firm. It also helps you achieve your strategic goals. Your strategic goals are not pursued in a vacuum. And when you define your strategic goals for where you want to take your legal practice, you also need to consider what risks there are to your achievement of those goals. So if you have a process of risk management in place, that will assist you. It will also assist you meeting the regulatory requirements. The regulatory prescripts and its compliance are on their own a huge risk, and if you have a system in place to meet them, you'll avoid action by the Legal Practice Council. And if a solid, effective risk management system will also enable you to concentrate on the practice of law. Imagine for a moment if a risk materialized and you had to spend a significant amount of time and resources either defending an action brought against your firm or dealing with matters at the Legal Practice Council, that will take you away from conducting your main business, which is the practice of law. A positive risk profile will also assist you in obtaining insurance cover at beneficial rates. Remember that in the commercial market, insurance companies do a risk assessment on you, and then they use that to decide firstly whether or not they accept your risk, that is your business, and then secondly, if they do accept your business, they also use that to decide what the terms are on which you will be indemnified. Those terms include what premium you will be charged, what excesses will be built into your policy. But if as an insurer can see that you take risk management seriously and that you've got risk mitigation measures in place in your practice, they'll look at that favorably. And risk management also will save your pocket. You won't have to spend money paying claims that are not indemnified, and you also won't need to pay insurance excesses, because when you pay an insurance claim, there's always an excess payable. And a good risk management system will give you an edge over your competitors. I often make the suggestion to legal practitioners that in those who have good risk management systems in place should highlight that in their profiles and any other documents they prepare in order to get business, whether it's additional business from existing clients or new business from prospective clients. In an increasingly competitive world, if you highlight what systems you have in place, highlight how important you take risk management, that would give clients some ease, and they may then decide based on that you take yourself seriously, and therefore you take their business seriously, and they can take a chance on you, and they'll sleep easier at night, knowing that they've given their work to someone who has systems in place to ensure that there are no losses. And lastly, risk management will save your reputation. As we go through this presentation, you'll see from the cases that there are a number of law firms that are mentioned, some of them not in a positive light, and also the same applies to a number of individual practitioners who are mentioned in the judgments. In this very connected world, clients, one of the things they may do when they're looking for a legal representative is to do Google searches. You don't want your name coming up in a negative light. And remember, in this interconnected world, bad news travels very fast. And so if one client has had a bad experience or finds out some negative information about a law firm, they're most likely to tell others as well. There are many other benefits of risk management, but I just thought that I would just highlight these as an example. So where do the dangers lie? So what are the main risks facing legal practitioners? These will be unpacked further in the next series of videos, but I just want to list them for current purposes. First is a failure to comply with the statutory time limits. You'll note when we look at the claim stats, what a huge problem prescription is. Cybercrime. This is an increasing the risk that's facing legal practitioners in South Africa as well as in other jurisdictions. Cybercrime has been a problem, particularly since about 2010, when we saw a spike in cybercrime-related claims. Theft of funds. People want to steal your money, and they'll take their chances if you don't have adequate measures in place. Unfortunately, some of these people may be internal, others are external, and I always say, thieves don't discriminate. They'll steal money, whether it's your business funds or your trust funds. They just want to get their fingers on your hard-earned cash or that of your clients, so forth. And if they get their money on the funds of your clients that you are holding in trust, unfortunately, the client will look to you for to repay those. Under settlements, these are cases where legal practitioners settle matters, litigious matters mainly, for amounts that are less than the damages suffered by their clients. And the client will then sue the attorney for the difference. This is a risk that also talks to issues regarding how you record your mandates from clients, how you report to clients, and the need to take instructions from your client repeatedly over the matter. Every time there's a development, please report it to your client and take an instruction. But we'll also talk about that in detail later. A failure to adequately carry out mandates, you'll see the effect of that when we in the numbers for the claim stats. Compliance and regulatory requirements, when you miss those, you get them wrong, you'll get into trouble with the Legal Practice Council. The inadequate management of relationships with clients and other third parties, will also go into that in detail. And then proper supervision of your staff, both your professional and your support staff. Supervision, we don't say advocating that you should stand over your staff and to police them at all times. What we are advocating is to have a system where you can ensure that everybody in the firm is doing what they're supposed to do timeously, and that the output is of a sufficiently high standard that is expected by those to whom your services are rendered. And remember that it will be no excuse for you to say whether this is in respect of a professional indemnity claim or a disciplinary inquiry at the Legal Practice Council. You can't say that I gave the matter to my trusted staff member who ran the matter on their own. Ultimately, the buck stops with you. And supervision can be a two-way street, in the same way that you supervise those people who report to you, so that they can also give input, one, because they're at the coalface on where they see potential gaps in the risk management system, and secondly, they can provide some sort of peer review over the work that you do. If we could just look at the claims statistics to help you see where the high risk areas are in practice. At the end of 2021, the LPWF had more than 2,300 active claims, and the total value was close to 700 million rands in those claims. Remember that these are only claims that are reported to the primary insurer, that's the LPWF, because it indemnifies all practicing attorneys and advocates with trust accounts who are in possession of a Fidelity Fund certificate. If we were to look at the value of claims from the commercial insurers as well, the numbers would really be significant. So RAF prescription, RAF under settlement, litigation, general prescription, conveyancing and commercial matters are high risk areas that you'll see from the claim numbers. What we've done in order for the pie chart not to have too much information, we've just bundled all the other claim types in the last category, other. This is just another representation of the outstanding claims. You'll see how RAF prescription claims by far are the highest in number. And I would also mention that RAF prescription claims notified to the LPWF make up more than 60% of both the number and value of claims notified. Conveyancing has been a problem, particularly since late 2007, when the property bubble burst. So between 2007 and 2016, we then had lots of bridging finance related claims that were also targeting conveyances as well as cyber crime related claims. So deal with both of those in detail when we talk about the specific risks. I would also like you to bear these stats in mind when we look at the specific risks in practice, and maybe that will also help you understand why certain risks are emphasized more than others. It's just not practical in a course of this nature to go through every possible risk, so we just choose the main ones. In order to find the common errors and omissions that are committed by legal practitioners, we take all the information that is provided to us when claims are notified, and as we're dealing with a claim over its life cycle. We analyze all that information and the data and try and pinpoint what went wrong in the practice that led to the claim against the firm. You'll note that a failure to carry out the mandate correctly that is by far the largest error. And the category just above that, a failure to confirm instructions, as is also a related error. Lapsing of summons, as well as failure to serve summons timelessly, make up the second highest category. And then those are issues of prescription, which we'll also delve into in detail. Sometimes it's easier to learn from the mistakes that are made by others, and I often say that we learn a lot by listening to war stories of where other people have made errors and omissions. The point is not to badmouth anybody or to gossip or to sit on a high horse, but it's really important to look at what has gone wrong previously and to try and develop behavior that will not allow us to follow in the same route. Claims against legal practitioners have been on the increase since 2008. When we look at what has happened in several jurisdictions internationally, we see that they've also had similar trends, and their risk areas are similar in many ways to those in South Africa. At times they may have different terminology, but I think the underlying principles are the same. But these 6 points are specific to the South African environment. First of all, we noted that in some firms, there is a lack of adequate risk management measures. Some firms concentrated on trying to build a firm, or a firm was working well, and risk management was placed on a back burner. That's if it was even considered. It wasn't seen as something important, but there's been a change, I'd say, since about 2017. There has been some change in the attitude of legal practitioners to risk management, and people are taking it more and more seriously. We also had the emergence of new risks, cybercrime and bridging finance. As I've mentioned, cybercrime from about 2010, bridging finance from about 2017. I'll explain both when I deal with the specific risks. There's also been a significant growth in the profession in the last decade. There are currently just over 26,000 practicing attorneys in South Africa. As the profession has grown, there hasn't been a concomitant growth in the legal services market. So there have been more lawyers in practice, but the cake to feed us all hasn't grown at the same rate. And that has presented certain risks. In some instances, it has meant that people have extended themselves, for example, to do work that they did not particularly have the knowledge or the speciality for, or maybe not even the appetite for it, but they pursued it because it brought in money, brought in fees, and they made mistakes in the process. As other areas of work, such as the RAF type of work, have been on the decline in recent years, and so legal practitioners had to find other areas to pursue, and the pursuit of professional indemnity claims then became an option for some of them, and that is why you had the huge spike in people pursuing medical malpractice claims after 2010, and so others have decided that pursuing claims against legal practitioners is the way they would go. Not every claim that is made against a legal practitioner is a valid claim, but that does not stop people from pursuing them. The result is that insurers like the LPWF have to spend a lot of money defending those claims. Society has become increasingly litigious. Gone are the days when members of the public took what a lawyer said as gospel and did not question it. In the same way that members of the public are holding other service providers to account when they lose money, so they are with legal practitioners as well. Just finally, just want to talk about some topical risk management subjects, which we will go into in detail as well with the specific risks, but I just want to highlight them just for purposes of the introduction. The economic recession Studies show that at times when there is an economic recession, there is an increase in claims against legal practitioners. The reasons for that are rather complicated, but for example, if people find that either they've lost money or they did not make the money that they thought they would make after pursuing dealing with a legal problem, they turn to the lawyers and institute action against the lawyers. Also, internally in law firms, economic recession means less fees. You sometimes have to let key staff go. Because you need to retrench and try and cut your operating costs. You may not invest that much in the systems you need to have in place, and that is fertile the ground for risks to materialize. The coronavirus pandemic has now been with us for just under 2 years. The effects both on people personally and professionally have been profound. A lot of law firms either to downsize, go out of business. Others were not geared to operating in the remote and hybrid manner that we are operating now. There was a lot of confusion also at the beginning of the lockdown, particularly during the period of the hard lockdown, on whether lawyers could operate. First of all, that is whether they were an essential service. And then after that, people had to change the way they operate. And not everybody had invested in the appropriate systems or understood what was that required. The coronavirus pandemic has also had a huge impact on economic activity, and yes, people have less money now than previously to spend on legal fees. Business interruptions, load shedding, and interruptions to water supply and other municipal services are examples of business interruptions, which we'll talk about. I've addressed the issue of whether there's adequate work to support all legal practices. It has been interesting to note that during the pandemic, the numbers of legal practitioners who have decided to start their own practices has been surprisingly high. We don't know yet what the reason for that was, but one of the reasons that has been advanced to us is that when law firms were retrenching staff, those legal practitioners needed to find something to do in order to earn an income, and they went to open their own practices. Other people realized that the firms that they were part of, or that law firm structure, was not something that they wanted to do, and they rather wanted to operate on their own and thus open their own practices. Other people felt that it was a huge opportunity to go and start boutique firms, that's highly specialized firms servicing a select group of clients, or even to work from home. And with time, we'll see how that will pan out. A question has been raised about whether the formal education, that is the university education, and then the training system adequately prepares practitioners for what they'll face in running legal practices. That's an ongoing debate, and I think that the practice management training and the other courses that are provided by institutions like LEAD are aimed at addressing that gap. And then When we talk about the various measures that you can implement in a law firm, always bear in mind that those measures need to be implemented by human beings. Human beings are affected by a myriad of issues, personal and professional. And when they are dealing with those issues, they will take their eyes off the ball. Some people may just be present in the office physically, but their minds aren't there. That is fertile ground for mistakes to occur. In Australia, for example, in New South Wales, a part of their risk management system is to have a conversation with the legal practitioners to see what was going on when the error or the omission was made. And what they've said to us is that they've found that practitioners do say that, and this is 2 or 3 years after the fact, that at the time I was dealing with something, and just only strikes me now that that made me take my eye off the ball. So mental health and the psychological well-being of the people, of you as a legal practitioner, and also of the people that are operating in your firm, is very, very important. I've written articles on this, which are available in the practice management column of the Rebus, if you'd like to have a look at it. But remember that your risk management is not carried out by machines, but by human beings, and it's thus important that you keep you try and do everything in your power to ensure that those people, the mental health and psychological well-being of those people, it's yourself included, is taken care of. The LSSA has started a project on that aimed at addressing mental health and psychological issues. Please have a look at the LSSA website for information on that regard. Legal practice in the best of times is a pressure cooker environment where we are facing various challenges, trying to deal with the interests of various stakeholders simultaneously, and the current operating environment in the COVID pandemic and everything that's happening in the world has only exacerbated that. So thank you very, very much for listening to me in the introduction. I'll see you again in session 2. Thank you.